Afternoon. My name is Flavia Martin, and today I will be presenting to you a presentation about contract law, its governing rules, and the importance of justice among private parties. The law that ties moral obligations to keep one's promise with a legal duty to perform such promises has evolved into being contract law. Contract law relates to agreements and promises, but not all promises are legally enforceable. Contract law has helped to structure our justice system in providing guidance on how to deal with different contractual issues among adversary parties, which ultimately benefit those less fortunate to mostly gain a fair settlement. The legal definition of a contract is an agreement between parties that creates mutual obligations enforceable by law. While a promise may seem at times as a moral obligation, which will not carry any legal obligation if the promise is broken, a contractual promise carries more weight. If one party breaches its promise, a court may order a person to keep their promise by either ordering them to specific performance, or a person may be ordered to pay compensation damages for its breach of the promise. A contract is made up of four elements, which are an agreement, consideration, contractual capacity, and legality. Contracts are mainly governed by either state statutory law, common law, or private law. For example, under state statutory law, the statute of frauds may require some kind of contracts to be put in writing and executed with particular formalities for the contract to be enforceable. While under common law, consideration was the primary test used by the courts to establish if the parties had formed the necessary intent to enter into a bargain between each other, from which each party will incur both a benefit and a detriment from. Lastly, under private law, it primarily includes the terms of the agreement between parties who are exchanging promises, and it may override many of the rules otherwise established by state law. The impact of the involvement of contract law in our society from a moral standpoint is the following. In the old days, if a poor man entered into a contractual agreement with a wealthy person, that poor man was mostly at a loss if the most powerful party breached the contract, because contract law was not fairly applied within the court systems at the time. However, this is completely opposite to today's contract law application within the court systems, in where the most in where for the most it does not matter the type of social or economic stance that a party may hold in order to get a proper ruling. Although contract law has helped to structure our justice system in providing guidance on how to deal with different contractual issues among adversary parties, those same laws have also deterred certain mortals within individuals in our society. Back in the day, kids were taught by their parents that a man's word is worth gold, and one should never break his word after it is promised to another. Unfortunately, in today's society, those same morals seem to have decreased more and more as the spread of contract law seems to have expanded. Most people today rely on contract laws to back them up, and one's word has become a myth of the past, which no person can rely on because people have become more interested in their personal gains and less in doing good by others. A couple of legal principles that have shaped contract law into the way it was and into the way it is today is the liberty of contract, which is also known as freedom of contract, and the equity and fairness theory. Under the freedom of contract, the idea is that bargaining parties were free to develop a contract however they wished without the interference of a third party. Under common law, philosophers at the time believed that contract theory insisted that the unrestricted exercise of freedom of contract between parties who possess equal bargaining powers, equal skill, and perfect knowledge of relevant market conditions maximized individual welfare and promoted the most efficient allocation of resources in the marketplace. Karen Edwards actually noted in an article that the freedom of contract theory was seen in the earlier ages as a presupposition of the whole economic order that promises will be kept. Under this theory, contract thus became the indispensable instrument of the enterpriser enabling him to go about his affairs in a rational way. A couple of earlier cases that supported freedom of contract theory were, for example, in 1890, in Ex parte Kuvac, where the Supreme Court held adversely to a municipal ordinance which prescribed 8 hours as a day's work on public works on the ground that it was infringement of the right of persons to make and enforce their contracts. While in 1901, People v. Collar, the Court of Appeals of New York passed adversely upon legislation with reference to hours of labor and wages in municipal contracts. The opinion of Justice O'Brien in that case was a vigorous discussion of economic and political objections to labor legislation from the individualistic standpoint, which insisted that such legislation was of no real benefit to the laborer and was subversive of his natural rights. A few scholars who also supported this freedom of contract theory were, for example, Aristotle, who believed some men were rightfully superior to others, Grotius, who also believed that the school of law mentioned liberty of contract as a natural right, and Kessler, who believed that the theory did not pose any threat to social order as a whole. The basic reasoning behind the freedom of contract theory was that all those ideas were based on the presumption of party competence. Courts were not to inquire into the fairness of the contracts or contract content, but to exercise restraint and to enforce bargains as made. Thus, the responsibility of the courts to protect those who were weak and vulnerable did not extend to parties who suffer hardships simply because they failed to protect themselves. This is when the principle of equity and fairness came into being, which was implemented by the courts of equity in order to recognize the facts of human intercourse. It actually focused on human dignity, and Pope Leo supported this theory because he believed liberty of contract was absurd and exploited individuals. Some of the benefits from the implementation of the equity and fairness principle, which uphold and continue to uphold human dignity in today's state, had to do with wage controls, which, for example, established a minimum wage requirement, as well as acceptable working hours, in where 8 hours of workday became the norm. Also, working conditions in where now employers were required to provide a safe and sanitary workplace for its employees. And lastly, labor rights, in where, for example, if an employee got injured at its workplace, he now had workers' compensation offered for him for its protection. So, how does the implementation of contract principles and the involvement provide private parties with more rights? I believe it's important to recognize that liberty of contract theory was not applied fairly amongst the members of the community because in the old time, equal parties did not really exist, which allowed the more powerful members of society to impose unjust and cruel bargains upon the weak and vulnerable individuals. However, the implementation and initial enforcement of such rules, however defective, were imperative for a working economy and stable society that will evolve into being free of chaos and abuse towards the less fortunate. It is just as important to know how, thanks to the implementation of the equity and fairness theory today, we continue and enjoy more rights. Today, we have rights to fair compensation, which ultimately benefit our families' lives, the upbringing of our children, the education of our children, because parents can actually now enjoy more time with their loved ones rather than worrying about having to work inhumane hours to make enough for a decent living. As well as members of the community who feel superior to others can no longer continue on entering into unreasonable contracts with private parties, leaving one party at a disadvantage. And the health, safety, and welfare of private parties it has continued being the main focus of our government protection, in where now employers are required to provide a safe and healthy environment for their employees to work. I really appreciate you watching my presentation, and I truly hope you've enjoyed it.